Good afternoon, everyone. It's Standing Committee on Justice and Human Rights. We're in meeting 33. We had meeting 32 not that long ago. So, as of the orders of the day, pursuant to the order of reference of Monday, June 16th, 2014, Bill C-36, an act to amend the Criminal Code in response to the Supreme Court of Canada decision in Attorney General of Canada versus Bedford to make consequential amendments to other acts. We have a number of witnesses. Welcome, witnesses. And I'm going to introduce the witnesses, and then we will go back as they are presented on the page in front of us on the agenda, who will speak first. And then each organization only gets 10 minutes. So it's not 10 minutes each, it's 10 minutes per organization. And then there'll be the question and answer period. And our first set of let me introduce all the witnesses. Walk With Me Canada Victim Services are here with Mr. Hooper, who is the chair, and Ms. Nagy, who is the founder of a Frontline Victim Care Worker. We have the Canadian Alliance of Sex Workers Law Reform, and Emily Labarette is the spokesperson, and Naomi Sayers is here as a spokesperson, the Criminal Lawyers Association. Leonardo Rosamano. I married an Italian. I had to do that. And with the Criminal Defense Council, and Anne London Weinstein, Director of Board of Directors. As individual, we have Professor Benedict from the University of British Columbia, and via video conference from the School of Criminology in Simon Fraser, we have Professor Lohman, who's joining us by video conference. Welcome, everyone, and each organization individual has 10 minutes, and first to start is Walk With Me Canada Victim Services.
I'm a survivor of sex trafficking, founder and frontline worker of Walk With Me, an organization that has been working 24/7 on the ground with victims of sex labor for the last 4 years here in Canada. 90% of them were Canadian girls between the age of 15 to 21 that were rescued from domestic sex trafficking. I originally entered the sex industry when I was forced into it by traffickers, and sometime after my rescue, I went back to the business for a few months, responding to a huge financial crisis. I already knew what I got myself into, and I voluntarily returned. But by my choice to prostitute myself to make a living and to avoid to become a homeless person, and also to be able to put food on my table. In the media in these days, we hear the voices of women who are sex workers who demand that their human rights be respected in their choice of work. Those women, though, represent a small percentage of women in prostitution. Studies estimate the number of women voluntarily making an informed choice to do sex work is between 1 to 10%. I speak for the other 90% of prostituted women and men whose voices are not largely being heard in this debate, precisely because they are still trafficked and they are still forced to do this work. I speak for the 60 to 95% of women in the sex trade based on numerous studies who were sexually molested or assaulted as children. I was sexually molested between the age of 12 to 17, and that background sets up to be abused again. I speak for the 70 to 95% of people who were physically assaulted while in sex work. My first encounter when I was sex trafficked was in a massage place where 3 Russian men entered into the room, and I was nonetheless just become a meat. That 3 men just started to take a little piss out of me. And I was lying on a table, on this very cold massage table, and I closed my eyes and I looked up, and I was thinking that if anyone would have seen this, would anyone come and rescue me, only to find out later that my so-called bodyguard was watching the whole thing on video. I was indoor. It was safe. They paid for their services. But nobody told me the rules because I was new to it. So I was raped for about an hour by 3 different men. I speak for the hundreds of Canadian girls that I have met and talked to and rescued in the last 4 years who have been and continue to be raped, violated, and exploited against their will. First of all, prostitution is not a profession, it's an oppression. 90% of the time it's the only job in the world where you can go to work and every day there's a chance that you could be killed or hurt by your employer, the Johns or the pimps. The dangers inherent in sex work are well documented in researches. Prostitution always involves a power of imbalance between a customer who pays to have their pleasure met and a person who is hired to act like a sex puppet. Prostitution is rarely, if ever, about two consulting adults. For example, the husband and a father of 3 children will highly unlikely to go to his wife and kids and ask for their consent for daddy to be able to go and have unprotected sex that evening from a prostitute. And again, absolutely, there's no laws protecting the wife and children from the ripple effects that is to come afterwards. I speak for the vast majority of people in a sex trade from this is not a freely made choice among many choices, but for whom it is indeed an issue of human rights, rights of liberty, equality, dignity, safety, all of which are being ripped from us on a daily basis. There does not appear to be a perfect answer in this debate. The rights of some will be curtailed to support the rights of others. Sometimes that is what laws is forced to do. The only way that they can be encouraged to seek help is by decriminalizing their part in prostitution and by creating an environment of safety and support that gives them valuable exit options. The legislation attempts to do that. There are 2 groups of people impacted most by this legislation. Pro-prostitution advocates speak loudly and with resources behind them. But there is the other voice of those trapped and tortured needs to be heard as well, and they deserve to be protected by this country. Trafficked men and women and those others who would rather do something else if they had a viable choice don't have the same voice. We need the government of Canada to do that voice for them, and we believe that Bill C-36 is that legislation that will protect our most vulnerable. Thank you.
Ms. Trooper, do you have anything to add then?
Yes, Mr. Chair. It looks like about 3.5 minutes, so I'll try to.
That is absolutely correct.
Try to be quick. On behalf of Walk With Me Canada, thank you. We support this Bill C-36. We think that the abolition of the purchase of sexual services is germane in the ability to curtail human trafficking in this country. All of the research that we have seen both anecdotally and quantitatively shows that demand is directly linked to trafficking. Therefore, we applaud the sections which criminalize the purchase of sex in this country, given that our frontline work is human trafficking. We cannot, the second thing that we see is that having the person delivering the sexual service being criminalized is not something we can support in any great way other than in the school religious setting as set out in Bill C-36, because from our perspective, over 70% of the people who come to use our service come through a police link, and therefore, if there is no trust in that triangle of police, the person in the sexual exploited situation, and our organization, the exit strategy, in our view, will fail. One of the things that is not covered in the bill that is in our paper that we would like this committee to consider is the recruitment of children. And I'll give you 3 fast statistics from research that we have uncovered, that a study in 9 countries say that 47% of people who enter prostitution do so at an age under 18 is when they enter the work. A study recently released by the Alliance Against Modern Slavery says at least 43% of people in Canada who enter is under the age of 18, and that included a section on forced marriage. And there was a study done by the government, the Canadian government, in 2004 that showed that the mean age of the entry into prostitution in Canada was 14 years old. So those studies are readily available. One of them was done by this government in 2004 by the government of Canada. So in our paper, we've set out in our view, some very good reasons why this committee should consider an amendment, much like the provincial sections for protection of children who are vulnerable, and that they can be apprehended, not criminalized, but apprehended by the authorities. We don't allow people to drink and smoke in this country, but apparently they can enter prostitution at 14, but you can't vote, you can't drink. And so we can't see why there shouldn't be an amendment that would allow children under the age of 18 found in this in prostitution to be apprehended as a child in need of apprehension. The last thing in my probably time I'm over is the $20 million. We want to encourage this committee to really be serious about the money that's put into the exit strategy, because as we see when you compare the Sweden and Norway, which are different, slightly different models, but Norway put no money into exit and Sweden did, and if you read the research, the results are very, very, very different for the exit strategy. So I would encourage the committee and the government to look at those issues, and that we be very serious, and I may be speaking from a bit of a partisan position in that we're frontline workers, or I'm not, but I'm the chair of a frontline worker organization, but certainly an exit strategy, I've heard many versions, but this is a holistic approach, has to be taken from re-education to recovery, to counseling. There's lots of studies that say this is similar to war veterans and post-traumatic stress disorder when you come out of a prostituted trafficking situation. There isn't a difference between prostitution and human trafficking in our view, in our organization's view. The demand for prostitution is directly linked to the financial gain of traffickers. If there's no demand in this country, then it is our view that trafficking will reduce, and maybe that will put us out of business, but we'd be happy to go out of business, Mr. Chair, if that was the circumstance. We have looked at it constitutionally, and we think that this does meet the Section 7 requirements, and we've also looked at Section 1, the notwithstanding clause, and had that looked at by people in our organization, and we think Bill C-36 is sound, and with the amendment with children, we support the legislation.
Okay, thank you very much. That was 10 minutes right on. Thank you for those presentations from Walk With Me Canada Victim Services. Our next presenters are from the Canadian Alliance of Sex Work Law Reform, and the floor is yours.
My name is Émilie Laberté, and I am a sex worker, and I'm here as the Francophone spokesperson for the Canadian Alliance for Sex Work Law Reform. Sex workers have not been central to this reform, which could implement laws that directly affect our working conditions in our lives. During the private consultation that Peter MacKay held on March 3rd, 2014, only 3 sex workers were on the table, and the minister clearly explained that he had no intention of consulting sex workers in Canada. Bill C-36 and the terminology that is used, as well as the statements made by the Minister Peter MacKay, clearly indicate that the legislators' goals are moral by criminalizing a practice that they believe to be exploitative in and of itself, despite the consent of adults who participate in it. Rather than rely on the vast amount of compelling data demonstrating the devastating role of criminalizing prostitution, the new law rests on an ideological foundation. Bill C-36 is also based on the victimization and infantilization of our community and does not recognize the autonomy of extremely personal decisions or the capacity for consent. In the light of this moralistic vision, we have this bill. In light of this moralistic vision, we have a bill which, as written, does not respond at all to the Supreme Court of Canada's ruling and to the spirit of the Bedford ruling, which is intended to respect security measures that we are implemented and which are necessary to protect our lives. On the contrary, what is proposed reproduces the same problems and is even more repressive because it targets the sex industry as a whole, which prevents us from deploying all security measures and infringing upon our constitutional right to security, life, and liberty, as well as infringing upon our freedom of expression, association, and equality. The objective of Bill C-36 will have the same negative effects or create even more negative consequences because it maintains the same objectives that were deemed unconstitutional. Under 213(1.1), this law applies to any public space, but the new one applies only to public space where young people could reasonably be expected to be present. The scope of the bill would be too broad. It could include many places where sex workers receive their clients. Peter MacKay named hotels where sex workers work. As this This law would work almost the same way as the former law, which was declared unconstitutional under Section 7 of the Charter because it creates dangerous circumstances that do not take into account sex workers' travel and our capacity to communicate with the intent of pre-selecting our clients for security reasons and establishing clear agreements. The new bill does not respect our constitutional right to life, security, and liberty. 286.1. The impact of criminalization of our clientele on our lives and our work are already known. Clients were already subject to criminalization under former sections 210 and 213. When the police get involved, there's always more violence. When prostitutes often end up accepting clients that they would otherwise have refused, and for lesser cost. Violence can also include murder. If this bill becomes law, clients will not provide information on themselves, which is essential to protect ourselves from people who are badly intentioned. This approach is in contradiction with the Bedford decision because it criminalizes clients as well as our professional and personal relationships and infringes upon our right to personal safety. 286.2 and 286.3.1. This is a more limited version of the former offense of living on the avails of prostitution. The possibility of working together or hiring people that provide security services is a key component to ensure our security. This provision is very broad, and it was struck down in the Bedford ruling because these services are necessary for our protection and are important for breaking down isolation. When it comes to 286.4, this section could apply to sex workers who group together and advertise their services. Without being able to advertise in any type of media, we have very limited means to work safely in private, as well as further isolating the sex workers. This clearly goes against the spirit of the Bedford ruling, which is intended to protect our capacity to work indoors and in private to minimize risk. The sites that we have allow us to gather a great deal of information, and it also allows us to exchange information between sex workers in order to discuss security, validate references from our clients, exchange with third parties. These are all essential parts of the information that we need to ensure our security.
Ontario sex workers. And who is a member of the Canadian Alliance for Sex Work Law Reform. I'm an Indigenous woman from Northern Ontario and a former sex worker who with experience in working both in Northern and Southern Ontario. I will elaborate on how Bill C-36 negatively impacts Indigenous women and finish with recommendations for moving forward. We make it clear from the outset we do not support Bill C-36 or the use of criminal laws that target sex work. We propose instead a process that meaningfully includes people who work in the sex industry and that includes labor and regulatory measures that prioritize safety. Canada's greatest social injustice is the issue of missing and murdered Indigenous women. Other witnesses will argue that the criminal laws against clients and third parties will protect Indigenous women from going missing and murdered. We argue the opposite. Not only does this flawed argument ignore the fact that not all missing and murdered Indigenous women do not work in the sex trade, it also ignores the facts that they experience institutional and systemic violence as Indigenous women, especially like the state's role in making a sex worker vulnerable to violence, such as Chief Justice McLaughlin highlighted in her decision. Wally Alpo in his Missing Women Inquiry Report also recognizes this when he states, the marginalization of women is due to the retrenchment of social assistance programs, the ongoing effects of colonialism, and I emphasize the criminal regulation of prostitution and related law enforcement strategies. Chief Justice reiterates the harmful effects of criminal regulation of prostitution when she states that the criminal laws not only impose conditions on how prostitutes operate, but the laws go a critical step further by imposing dangerous conditions on prostitution. This reminds us to respect the spirit of the Bedford decision and that our objectives need to prioritize the health and safety of people working in the trade, not the elimination of the industry. The criminalization of clients in Bill C-36 has devastating impacts for Indigenous women who rely on income generated from prostitution, particularly in the context of inadequate housing, social services, or education. Indigenous women will seek out clients in more dangerous areas, and clients will rush negotiations, putting women at risk. The isolation and inability to screen clients for safety contributes to the rising violence against sex workers. Indigenous women are already targeted by aggressors, as seen for over 20 years in Vancouver's downtown east side. Chief Justice wrote, "If screening could have prevented one woman from jumping into Robert Pickton's car, the severity of the harmful effects is established." Trafficking has also been raised in the discussion of the bill. While exploitation happens in the context of trafficking, Bill C-36 does not distinguish between exploitation and prostitution. It assumes that prostitution is exploitation. Chief Justice highlighted that the old laws were overbroad and that conflating prostitution with human trafficking does an injustice to the victims of exploitation. The Global Alliance Against Trafficking in Women, an organization that prioritizes trafficking victims, highlights that criminalizing clients diverts precious resources from protecting victims of trafficking, who urgently need help in a politically contested and futile anti-prostitution campaign, and that criminalizing clients ignores the structural issues that cause forced labor, thereby distracting from the government's responsibilities to victims of exploitation. Consequently, we argue for the use of current existing criminal laws that address exploitation rather than reframing prostitution as exploitation itself. More importantly, Bill C-268 made further amendments to the criminal code to combat human trafficking related to children. This bill received assent on June 29, 2010. As the Global Alliance Against Trafficking in Women asserts, conflating exploitation with prostitution ignores structural issues contributing to forced labor and diverts resources away from victims of exploitation and toward a highly politicized and futile anti-prostitution campaign. We argue that we need to adopt a model respecting Canadian values entrenched within the Charter. We recommend adopting a rights-based approach like the New Zealand model to protect the most vulnerable and marginalized groups in society. In 2003, prostitution was no longer regulated by criminal law in New Zealand. The trade is regulated through labor laws and occupational and health and safety standards. New Zealand sex workers find it easier to report incidences of violences, with police taking reports of violence seriously. Additionally, since 2004, New Zealand maintains their Tier 1 ranking status, the highest and most favorable status for combating trafficking, as reported by the United States 2013 Trafficking in Persons Report. We should focus on investing into resources, social supports, and sex worker-led organizations who work directly with sex workers to protect the safety of sex workers. The goal should be ensure that the safety and protection of all women in the trade by utilizing already existing criminal code sections. Despite what people may feel about prostitution, the reality is that people will continue to work in the sex trade. And in this context of Bill C-36, they will be at risk of more violence. Bedford demonstrated this risk. We hope the government will recognize this and prioritize health and safety.
Thank you very much. Thank you for that presentation from the Canadian Alliance of Sex Work Law Reform. Our next group of presenters is from the Criminal Lawyers Association.
On behalf of both of us this afternoon, as we did not think it reasonable to expect a lawyer to only be able to speak for 5 minutes. So he'll be encompassing my comments as well.
Thank you very much.
She's already taken 21 seconds.
But who's counting?
I'd like to thank you, Mr. Chair, for having us here. It's obviously very important that we have this dialogue on a very important piece of legislation. On behalf of the Criminal Lawyers Association, we focus on the constitutional aspects of Bill C-36, in particular, whether it may survive a Section 7 or a Section 2B freedom of expression constitutional challenge. And on that basis, we are opposed to this legislation. In our view, Bill C-36 is bad policy and bad law. The evidence that was heard at the applications level that was unanimously accepted by the Supreme Court of Canada is indisputable. That evidence is unchanged with respect to Bill C-36 and what it seeks to do, regardless of the loftier legislative objectives of C-36. The same harms remain when one takes the approach of asymmetric criminalization, in my respectful view. In advocacy in our courtrooms, lawyers like to think about facts as whether they are challengeable or indisputable. And when you have facts or evidence that cannot be moved, that's indisputable, then you have to absorb that evidence. You can't ignore it. And that comes to mind when we look at the evidence that was heard in the Bedford application and which was unanimously accepted by the Supreme Court of Canada. And it's beyond a shadow of a doubt that criminalizing the sex trade contributes to harm for sex workers. What we're talking about here is the most vulnerable people in our society. especially when it comes to sex workers that are in the street. And this legislation does absolutely nothing, in my view, to address that problem. The objectives that are stated in Bill C-36 are quite different than what was seen in the Bedford case. Instead of a primarily nuisance reduction objective that we saw in the previous legislation, we have these loftier objectives of eradicating prostitution itself, of discouraging people from entering the sex trade, of protecting sex workers themselves, of encouraging sex workers to go to the police when they suffer from acts of violence. This bill is trying to eradicate the sex trade itself. Something which doesn't connect with me is that it's trying to protect sex workers by driving them underground, by pushing them into the dark alleyways, by pushing them away from public view. And that was evidence which was heard already about what means sex workers employ in order to protect themselves. For example, communication, how sex workers screen potential clients to avoid potential dangerous situations. The provisions that are in C-36, in my view, do not do anything to address these harms, and the harms will continue. What we have now is a new setting where we have the same ill effects, but we have loftier objectives. So I'm going to try to word this in terms of a Section 7 challenge, because that seems to me a primary avenue of challenge. And under Section 7, as we know, in the previous legislation, there was a challenge on the basis of gross disproportionality and overbreadth. And so in any Section 7 challenge, we look at it in two parts. First, does the legislation deprive the applicant of life, liberty, or security of the person? In my view, it's established fact that criminalizing the sex trade does deprive sex workers of their right to security of the person. We look at now whether or not that is how it's related to the objectives of the legislation. So under the previous legislation, we had, for example, for communicating in public or keeping a common body house, we had the objectives of reducing nuisance and neighborhood disruptions. And the court reached a rather easy conclusion, in my view, that when you compare those two, when you compare the objective of reducing nuisance to the effect of actually contributing to the harm that's visited upon sex workers, that's just no contest. And the court very easily found, in my view, that the goals or the effects were grossly disproportionate to the legislative objective. What we have now is a loftier set of objectives, and something which in the academic literature we've seen, and we've drawn heavily upon in our research. Academics have referred to the Insight decision, the safe injection decision, when looking at the principle of fundamental justice of arbitrariness. So once we've established that there's been a deprivation of security of the person, is that deprivation in accordance with the principles of fundamental justice? And in my view, this legislation is vulnerable to a challenge on the basis that it's not only grossly disproportionate to the, albeit loftier objectives, but it's also arbitrary. In other words, the goal in no way bears any relation to the effects. The goal of public safety, the goal of encouraging sex workers to report incidents of violence to the police is in no way going to be realized. And the evidence is clear that when sex workers are not permitted to communicate, those that are most vulnerable, those that are in the street, when they're not permitted to communicate, this is a primary mechanism they use to protect themselves. That is going to contribute to the danger, and that will lead to a finding of arbitrariness, in my view. Something which an academic mentioned in an article recently in the Globe and Mail, Kyle Kirkup, who's a lawyer and academic, doctoral candidate at U of T, entitled an article, "Got a complex social issue? There's a jail for that." That is the overriding sense that I get from this legislation. The criminal law, the criminal justice system is a very blunt tool, and it simply does not have, it's not equipped to deal with this very complex social issue. The other challenge which is ripe for reconsideration is under 2B, freedom of expression. This was last challenged in the 1990 case, the prostitution reference. In the Supreme Court in Bedford has indicated that there is a possibility that cases that have been previously decided by that court may be reconsidered when faced with new facts and new arguments. The nature of the expression at issue, when one looks at a Section 2B challenge, we really look at what is the value that the expression is what underlying value can be seen from the form of expression. This kind of expression that we're looking at, the communicating in public, this is protective expression. This isn't just commercial speech. Again, the evidence is very clear. This is that sex workers communicate in order to protect themselves. And this, in my view, goes to the core values that underlie the freedom of expression that we all are supposed to be guaranteed. And it really comes down to whether it would survive a Section 1 challenge. And in my view, it would fail to do so on the basis that it's not proportionate at all, that it will further contribute to the harms visited upon sex workers. How does Bill C-36 protect the most vulnerable in our society? It doesn't do that. In my view, it simply adds to the harm that's visited upon sex workers. What is the evidence? The evidence is that it contributes to the harm. And as a society, I think we have an obligation to protect those that are most vulnerable. C-36 utterly fails to do that. Thank you.
Sir, thank you from the Criminal Law Association. Our next presenter is Professor Benedette. Here's an individual, but from the University of British Columbia.
That's right. Thank you very much. So I'm here today as a law professor and also as a lawyer who's spent the past 2 decades researching, teaching, and advocating for sex equality under Canadian law, with a particular focus on sexual violence against women and girls, including prostitution. And as the chair has mentioned, I'm presently a faculty member at the UBC Faculty of Law and a member of the Ontario and British Columbia Bar. And I provide pro bono legal services to women's groups. I represented a national coalition of 7 women's groups in their intervention before the Ontario Court of Appeal and the Supreme Court of Canada in the Bedford litigation. I'm here to testify in support of the provisions of Bill C-36 that criminalize the purchasers of sex and that criminalize exploitative profiteering from the prostitution of others as well as advertisers. I'm also here to oppose the provision that criminalizes those who communicate for the purpose of selling sex in areas where young people are likely to be present. I've read the provisions of Bill C-36 closely, and overall I would say this bill represents and reflects a very positive and fundamental shift in our collective thinking about prostitution, moving away from thinking about prostitution as a question of mere morals or nuisance and toward an understanding of prostitution as a practice of sex inequality and a form of violence and exploitation against women and girls. I think the government has recognized, correctly in my view, the overwhelming evidence that the global prostitution industry is not primarily a series of individual contractual exchanges between equal parties, but an industry, a profitable industry, that profits from the outsourcing of sexual subordination to the most disadvantaged women and youth among us. Unfortunately, some criminalization has been maintained for women on the street in this bill who are disproportionately Aboriginal women, and this provision, I would say, is inconsistent with the thrust of the rest of the bill. So let me say a few things in particular about 286.1, the provision that would criminalize the purchase of sex. And I want to be clear here constitutionally that when we talk about security of the person who is criminalized by this provision is the John, the buyer, and his security of the person is not at issue here through this criminalization. He's the source of the danger to women. I think one of the important features of this provision is that it's been grouped with offenses against the person in the criminal code, which makes clear that the act of buying sex in any location is a criminal act that is a form of exploitation and violence. I think that strengthens its constitutionality. That was not the case in the prior version of the code, where the prohibitions on Johns were partial, location-based, and grounded in nuisance concerns. The argument I hear raised most often in opposition to this position is that criminalizing the purchase of sex is unconstitutional because it pushes prostitution underground. And I think really there is something kind of ironic about the argument that men must be allowed as a constitutional right, unrestricted opportunity to buy women in order to keep women safe from those very same men. But to attack that argument a little bit more directly, I want to say to you that most fundamentally, prostitution is at its most underground when it is completely decriminalized. The New Zealand approach that we keep hearing being touted So long as the brothel has less than 5 women, it doesn't need a certificate, and it operates entirely invisibly, outside of the reach of law and other interventions. It's entirely under the radar. The second thing is that visible prostitution is not necessarily safe, healthy, or equality promoting. And the prison camp bunny ranches of Nevada or the mega brothels of Germany are 2 good examples of that. But third and most importantly, I would say that this argument at its heart is really disingenuous. It's the same old claim about choice that completely ignores inequality, but now masquerading as an argument about safety. And I realize that that's a pretty harsh-sounding statement to make, but to explain why I say that, let me just speak for a moment about youth prostitution and the criminal offense of communicating for the purposes of obtaining sexual services from a person under the age of 18. That's 212.4 in the current criminal code. It wasn't challenged in Bedford. It will reappear under the new bill, renumbered as 286.1 sub 2, I think. And so it's a crime to buy a young person for sex, including through communicating for that purpose. No one seems to be disputing the continued existence of that provision or questioning its constitutionality. It criminalizes exactly the same conduct as in the new 286.1 in very much the same language. And I'm confident that no one is going to come before this committee and ask you to repeal that section because it makes kids unsafe by pushing youth prostitution underground. They will not say, let's acknowledge that youth prostitution is inevitable and decriminalize the guys who buy kids because it will make the young people safer. They'll be visible, they can communicate, we can reach out to them. They will not argue that Section 7 of the Charter requires that men be allowed to buy kids for sex. And the reason why is there's a lot more to it than just saying, well, you know, adults aren't children. It's because we believe that young people lack the capacity to consent because of an inequality based on age. But the reality is, for young people in prostitution, there are many other inequalities at work, some combination usually of gender, the effects of colonialism, poverty, and addiction. But when that inequality of age is no longer present, some people refuse to see any of the other inequalities that are so prevalent in prostitution, even when the prostitute, who's now an adult, started as a child. So the fact that women in prostitution are overwhelmingly poor, that so many of them are racialized, trafficked to meet male demand, struggle with addictions, with intellectual disabilities, and the after effects of being placed in state care, these inequalities count for 0, so long as the woman is 18 or older and she's willing to take the money. And yet the Supreme Court of Canada did make clear in its decision in Bedford that many of those in prostitution cannot be said to be there by any real definition of choice, and that it's those women that our law and policy responses ought to be focused on. And we don't say, well, the criminal law that prohibits, purchasing young people for sex hasn't eliminated youth prostitution, so it's useless and should be repealed. Because we understand, just like the laws on sexual assault, just like the laws on wife battering, that the criminal law is there to serve a very particular denunciatory purpose, that it has a very real and important goal, but that it's not the only piece of what it is we're trying to do in addressing a complex social problem. But you'll never address that problem if you decriminalize prostitution and normalize it. And that's true in any country that has experimented with exactly that route. The final thing I'll say about the analysis that we've heard today is that, yes, we do have to think about Section 7 of the Charter, but we also have to think about Section 15, the equality rights provision, that was studiously kept out of the analysis in the Bedford case. But now we have a bill that makes clear, right in its stated objectives, that equality and equality for women and girls is an important consideration when thinking about prostitution. And that, in my view, means that equality and Section 15 can no longer be ignored in the constitutional analysis. I'll just conclude by saying something very briefly about the provision 213.1.1, the sale of sexual services where young people are expected to be present. I think that this provision is misguided. I do not think that the law should be making a distinction based on location if we understand the act of the purchasing of women to be an act of exploitation. It just punishes women for being exploited in the wrong location. I think it returns us to an approach rooted in nuisance. It's not really about protecting children because it doesn't criminalize women who are prostituted in front of children in a private place, only in a public place. I understand the concern about, well, the prostitute will be there on the residential street, and what can we do if we don't have this kind of provision to move her along? But of course, the police can do something because they've now got the provision that criminalizes purchase. Use that provision to target the Johns. That's how you deal with the prostitution on the street. It's how we should have dealt with Pickton, who was a known John who the police simply refused to arrest wherever he picked up women, on the streets, in the drop-in centers, in the bars of the downtown East Side. It's not just displacing women to other locations that is the issue. It's the refusal to interfere with the purchase of sex by Johns. So I think that provision really needs to be rethought. And ultimately, if it is removed from the bill, it will actually strengthen the constitutionality of this legislation. So I'll stop there.
Thank you, Professor. That was right on 10 minutes. Thank you very much. Our final presenter for this panel by video conference from Burnaby, British Columbia, is Professor Lohman from the School of Criminology at Simon Fraser. Can you hear me, sir?
Yes, I can. Can you hear me?
We can. The floor is yours.
Thank you very much. In addition to speaking today, I've submitted a written brief, which is much more detailed. I'll go over and review some of the material in that written brief and make some extra points. To introduce myself, I've worked on various research projects on prostitution since 1977, mostly in British Columbia. I did 9 different studies for the Department of Justice Canada, and I was on the board of a service organization for sex workers on the downtown east side called PACE. My main interest in speaking to Canadians about prostitution, and particularly legislators, is the hope that policy and legislation is based on reliable and accurate information. And I'm hearing all sorts of claims made about research today, none of which would actually stand scrutiny. Of course, research can't answer all of the problems that we're talking about, so I should also say what my own political value judgment is with regard to prostitution, and that is that I believe that the state should not prohibit consenting adult sexual activity, especially in situations where it endangers sex workers. I therefore disagree with those who say that 90% of prostitution doesn't involve choice, although much of it involves highly constrained choice. Some prostitution is entirely opportunistic. Some is sexual slavery, and the law should criminalize sexual slavery in every circumstance it should occur. But like most service and manual workers, sex workers make the choice to prostitute in situations that they do not choose, i.e. the capitalist political economy, colonialism, gender power structures, racism, and so on. Vast majority of the population makes those choices in situations that they do not choose. But we don't see criminal law as the solution to those inequalities. We started saying a few things about evidence claims on which the prohibitionist position is based. I've heard it said again here today that the average age of entry into prostitution is 14. In my written brief, I've reviewed the literature, and I've also gone over the review of the literature that was conducted in Bedford v. Canada. That is a preposterous claim. There is only one piece of research that supports it. It is a study of juveniles at excluded adults. If you look at the research, which includes both adults and juveniles, the average age is generally 18 or well above that. You also see examples of prohibitionist discourse using certain kinds of research and then generalizing it as if it represents prostitution more generally. You'll often hear Melissa Farley's research quoted, as indeed does Joy Smith's Tipping Point. She talks about 100 Canadian sex workers and what their profiles look like. The women on the downtown east side do not represent prostitution more generally. Most women are not trafficked. That's what the research literature says. Obviously, there's many, many different experiences, and some of them are truly awful. But if we want to talk about the nature of prostitution across the whole of it, we need to understand that there are many different kinds of prostitution. I would also note that Farley's work, which is so often quoted by prohibitionists, was also entered into Bedford v. Canada. Justice Himmel concluded that Farley's advocacy contaminated her research. I think that bears repeating. Let me just say something about the logic of demand-side prohibition. Demand causes prostitution, it is argued, so therefore if you get rid of demand, ultimately you will get rid of supply. It ignores Economics 101. Supply and demand interact. We live in a culture that commodifies female and male sexuality at every turn. Explicit sexual imagery is always only a few keystrokes away. Our culture produces the demand for sex. It similarly produces sexual capital on which supply rests. Race, class, and gender structures mean that sexual capital is the only capital available for some people. Let's take Economics 101 and look what it would do for the Made in Canada approach to prostitution prohibition. One of the first studies of prostitution conducted in Canada, when asked what initially of clients when conducted in Canada, when asked what prompted them to purchase sex, 41% of respondents said it was the availability and/or visibility of sex workers. Although the Protection of Communities and Exploited Persons Act prohibits third-party profit from prostitution, its section prohibiting advertising exempts a person advertising sexual services on their own behalf. The demand-side prohibition holds that the state should not hold sex sellers criminally responsible because they are victims of men. However, much as prohibitionists deny that sex workers ever exercise choice, many, and I would suspect most sex workers, don't agree that they are one-sidedly and only victims, even if some of them are victimized. They see themselves as agents acting on their own behalf, taking advantage of their sexual capital. They do not want to exit prostitution unless they do so on their own terms. Consequently, they will continue to advertise and sell sexual services, and legally so under the new regime. However, anyone who takes the bait will have the force of criminal law brought to bear against them. In which case, I say, Made in Canada prohibition amounts to state-sponsored entrapment of men. Asymmetrical prohibition will be subject to a Charter 15 challenge because it criminalises mostly male sex purchasers but not sex sellers, the large majority of whom are female. And a Section 15 challenge was coming down the pipe in the Pivot Charter challenge, by the way. That issue was going to be argued if that challenge had proceeded. What about supply? Demand is a necessary but not sufficient condition of prostitution. Focusing on demand means that the state will not have to address the factors that produce supply. We just blame the men. So colonialism, poverty, substance addiction, unemployment, gender employment structures, economic opportunity structures in a culture that produces sexual capital will be left as they are. For the people who rely on their sexual capital to subsist, demand-side prohibition will only exacerbate their problems, not least because patterns of law enforcement will not change. Since 1985, when the communicating law was enacted until the communicating law struck it down, 93% of all prostitution charges were of a street prostitution offence. Two main factors produce this enforcement pattern. First, it reflects patterns of complaint police receive about prostitution. Nearly all of them are about the street trade. Indeed, in every public opinion survey ever conducted, one area of clear consensus, and of course Canadians are deeply divided over the legal status of prostitution, but one area where there is consensus is that prostitution shouldn't be on the street. 89% of those polled in the June Angus Reid survey, which also shows that the majority of Canadians do not support Bill C-36, by the way, 89% of Canadians in that poll said that prostitution essentially should not be on the street. The second main factor explaining that law enforcement profile is the difficulty of procuring boarding house, living on the avails charges. They're time wasting. It's difficult to get evidence. Convictions were difficult, not least because sex workers have no interest in testifying against the people with whom they work. Police also knew that charges against off-street locations would reproduce exactly the same problems that put prostitution on the street in Toronto and Vancouver in the 1970s when police closed down off-street prostitution. How much would that pattern of enforcement change under the new law? It wouldn't change very much. And that is because if we look at Sweden, most of the enforcement, especially during the first years, was against people on the street. What are the police going to do in Canada to enforce this law against off-street clients? Are they going to set up bogus escort services, massage parlors? Are they going to entrap people? We come to a legislative golden knot. I too am opposed to the legislation which talks about criminalizing a sex worker in a public place or any place open to public view where a person under 18 can be expected to be present. Well, we heard the way to deal with the problem of street prostitution was to prosecute the clients, and we heard Mr. Picton's name mentioned. Well, as it happens, in the 1990s, the police in Vancouver deliberately set up a red light district in an industrial area. They deliberately had a policy. There was a news release. I can send you a copy if you like. And their entire objective was not to lay charges against the women, but to focus entirely on the men who buy sex. That particular area, the red light district, that industrial zone, which is where this particular provision of the legislation would try and force prostitution, became the killing field of Vancouver. That's where Mr. Picton picked up most of his victims. That's how successful this kind of legislative regime was when it was tried in Vancouver, as it was in the 1990s.
Professor, could you...
Yes, sir.
You have less than a minute.
Two recommendations. One, we've had a government arguing that this legislation will pass constitutional muster. That's the same government that argued that the laws that were impugned in Bedford passed constitutional muster. The government was completely wrong on that score. I think it is important the government send this legislation to the Supreme Court for an opinion about its constitutional integrity. Second, if you want to control things like street prostitution, and one of the catch-22s the government faces is the high public support for controlling street prostitution, is if you have a system of bylaws, zoning laws, you don't need the criminal law. One of the things that you understand if you study prostitution law enforcement in Vancouver over the last 30 years is police can move it at will to wherever they like, with one condition. Not just that they tell people where they cannot work, but where they can work. When they tell them where they can work, they can move them overnight. Thanks very much for your attention. Decriminalization is the way to proceed.
Okay, thank you, Professor, for that. Now we move to the rounds of questions, and I do ask committee members to indicate who your question is for so that the people can be ready to answer the witnesses that are required to answer. And our first question from the New Democratic Party, Madame Boivin.
So little time and so many questions. It's incredible. And I cannot talk. I talk fast, but I can't talk as fast as Émilie Laliberté. This is the ultimate fast. Je vais d'ailleurs commencer avec...
And so I'm going to begin with you, Émilie. Throughout this debate, we haven't really heard the voice of sex workers. And so I think I'm going to give you an opportunity to expand on some of the points that you perhaps would have liked to be able to speak further to. So I'm going to start with that. I'll give you about 2 minutes, but please slow down. So what I'm saying is that I'd like to know what you think about how this bill will make your work more dangerous. I'd like to explain that to the committee And I'd also like you to perhaps react to some of the comments that have been made by the other witnesses. I'm afraid I can't see the name, but the lawyer from the University of British Columbia. So I'd like you to respond to the comments to the effect that you aren't equal. Well, first, Ms. Benedict does not make the distinction between those who are trafficked and those who are consenting sex workers. My colleague Naomi said it very well. Those who do not want to do this work and are forced to do that are exploited, and therefore it's not sex work. And there are many articles in the criminal code that allow you to legislate, whether it have to do with human trafficking, domestic abuse, etc. So there are sections in the criminal code that do allow you to tackle that kind of violence, which is truly unfortunate. Now, with respect to this bill, I see the same legislation as what we had before, but it goes even further. For example, Ms. Benedict, and thank you, by the way, for giving me the opportunity to respond to her comments. So now the police will be able to deal with the Johns in the street. Now, yes, I am speaking on behalf of the Canadian Alliance for Sex Work Law Reform. However, I have also been a liaison officer. I've worked in the street with those people who have worked in the sex industry. I have been a sex worker. I've worked with many, many people in the sex trade. And what I've seen is that when the police arrest clients and Johns on the street, for example, in Hochelaga Maisonneuve, what happens is that there's even more violence for sex workers, so those who are engaging in sex work in the street. And under Section 213, there could be arrests on the street for those who were willing to purchase the services. Now, what happened was that then people went into further dark corners and alleyways. They didn't stay for as long out in public, and so their ability to communicate was reduced. They had to jump into a car really, really quickly because they were afraid, Johns were afraid of being arrested, and therefore sex workers were being exposed to even further risk. And this was documented by organizations. There was a list, for example, of bad Johns that had been drawn up. There was another organization working with sex workers in Ottawa, Gatineau. So this is backed up by this. In documents, including in Vancouver, by 2 reports that have just come out. So there are police officers in Vancouver who decided to change, for example, their tactic in 2013 and to target clients. So this was actually documented then amongst sex workers from 2013 to 2014, and what they saw is that there is even more violence. The parliamentary secretary has often said, for example, that there's nothing that will prevent you from doing this in the safety of your home, for example. What would you respond to that? Well, if there are children nearby, am I going to be allowed to meet the client? What if the child goes out on their balcony, for example, and sees? So, I'm sorry, it really is ridiculous to say where there may be reasonable probability that someone under 18 will be present. I mean, children can be in hotels. They can go in and out of hotels. So what you're doing, again, is criminalizing someone who's, for example, inside a body house, inside a home. So what you're doing is criminalizing someone. Then how do you respond to the other argument? For example, there are no exceptions. If you are doing it at home, we don't know exactly what legal advertising is, but in any case, the courts might determine that, as the minister said this morning. But let's just say, where's the client in these cases? I think it was Professor Lohman, in his brief, who referred to this entrapment, the likelihood of entrapment. And in fact, what's happening is that the bill is going to encourage entrapment, because if a client, for example, uses legal or responds to legal advertising, goes to your home and the police is there and the police arrest them because they've participated in that activity, what's happening? Well, that's a good question. And should that be our priority? Is that the message we want to send to Canadians? In other words, that this budget, the budget for everything, for our moral values, for the protection of citizens, the police force's budget, that all that is going to go to undercover agents in hotel rooms in order to arrest clients. Is that our priority, or is our priority tackling violence and using the articles that already exist under the Criminal Code against exploitation? My last question, then. For Mr. Rosamano.
Ask the question, and I'm going to send the question back, hoping for an answer. How do you define in this bill C-36 sexual services? Is it clear to your mind? Because as a lawyer, I'm not sure that I'm clear on the definition. There's no real definition. Could it cover, I don't know, lap dance? Can it cover? What are we treating exactly with C-36? Is it clear? And if it's not, isn't it a danger to, bring that to the courts, and it will be a good defense at some point in time?
Well, the short answer to the question about lap dancing is I think it would obviously include lap dancing. That sounds like a sexual service to me. And just a preamble here. When we talk about leaving things to the court to interpret, there's a cost associated with that. When we arrest people and then we let the courts figure it out. So that's just a preliminary thing. But with respect to sexual services, the one reference point that I have is with respect to our law on the offense of sexual assault, that the sexual nature of the touching, for example, is subjective in the mind of the victim. So that's one potential reference point. Will it be the person that is providing the sexual service that decides whether it's a sexual nature or not? I'm not sure. It seems vague to me, and it perhaps would even go further than lap dancing. I'm not sure even if, for example, an underwear model who has her picture taken, is that a sexual service? It seems to me that she's being provided consideration, and whether or not that's a sexual service or not is going to be left to the courts again. But there's definitely a cost associated with that.
Thank you for those questions and answers. Our next questioner is Mr. Decker from the Conservative Party.
Thank you, Mr. Chair, and thanks to each of our witnesses for being here. I think you brought some really important information to the committee, especially those of you who've been involved in this trade in the past. A lot's been said about the age at which prostitutes or women and men and others who get involved in prostitution typically get into the business. Ms. Nagy, I think in your opening comments you said that you know that many do between the ages of 12 and 17. Ms. Benedette, you mentioned that there are quite a few who join the profession under the age of 18. There are some, such as Professor Lohman, who disagree with that. Maybe I could ask the people who've been involved personally when they first got involved. Ms. Sayers, when did you first get involved in the sex trade? What age were you?
I was 18.
Okay.
And I was still in high school.
You were still in high school. Okay. Ms. La Liberté?
I was 19.
You were 19. And Ms. Nagy?
Well, I was trafficked under the age of 20, but the victims that we are working with now in Canada are, the majority of our victims are 16, and I'm not just making that up.
Okay. Ms. Sayers, you work with Indigenous women who are in this business. Do you know of any under the age of 18?
So I speak from experience. And London, Southwestern Ontario sex workers. And we work with Safe Space, which is an organization in London, Ontario that works directly with outdoor sex workers. They offer us literally a safe space for them to come. In London, predominantly the trade isn't Indigenous, but that doesn't mean that they're not there. We should offer, so speaking from experience, It's really hard for me to answer.
But have you ever met a underage sex worker under the age of 18?
Well, a sex worker can advertise however they want.
But have you ever met a person under the age of 18 who's
Well,
in the business?
I don't really ask. Like,
Okay. You don't know, but it's possible?
most people that I've met have been 18.
Okay. Ms. Benedette made an argument which I thought was kind of interesting. So let me ask you a question, Ms. Sayers, since you work with people in this industry. Do you agree with the criminal code provisions that make the sale of sexual services under the age of 18 criminal? Do you agree with that?
Can you repeat your question?
So there are provisions in the criminal code which were not struck down by the Supreme Court in the Bedford decision, which says anyone who's under the age of 18, who's providing sexual services, who is selling, communicating for the purposes of selling sexual services, that's still a criminal offense in Canada. And anyone who procures or encourages or employs someone under the age of 18, that's also criminal. Do you agree with those provisions?
I would like to quote Justice Himmel's decision where she stated that although those are important issues, child prostitution and human trafficking, they're not essential to analyze the charter challenge with the women that filed the charter challenge.
Okay, but so you're not saying either way whether you agree or not disagree with.
I'm saying I agree with Justice Himmel's analysis that those are two separate issues.
Okay, Ms. Nagy, what do you think? Do you agree that
Your question relates to Bill C-36. How does it relate?
I'm just asking you a question.
Do you agree that the current provisions of the criminal code, which criminalize some aspects of underage prostitution, do you agree with those?
Mais je vais appuyer les dires
I will support what Naomi said. The bill and the Bedford decision did not deal with juvenile prostitution. You're attempting to move away from the debate and Bill C-36.
We agree with that, but we would just go further and say that instead of criminalizing, we would like to apprehend under the child in need of protection under the age of 18.
Right. So Ms. Benedette's argument was no one is saying the provisions of the criminal code that continue to exist that criminalize some aspects of underage prostitution make it more dangerous for those prostitutes under the age of 18 and therefore should also be struck down. Am I getting that correct?
Not quite.
Okay.
So that's why I just want to, if I might, just to clarify. I'm focusing on the provision 212.4 that makes it an offense to buy someone who's under the age of 18. And what I'm saying is that no one is making the argument that somehow we better repeal that provision because it pushes child prostitution underground. So I'm focusing here not on the child who is selling herself, who is clearly not a criminal in any sense, but the person who is buying that underage prostitute.
So Mr. Russomano, do you agree with Professor Benedette on her argument about the purchase of the sexual services of someone under the age of 18?
I'd like to address that question, if
Sure.
I may, on behalf of the Criminal Lawyers Association. I think if I understand Professor Benedette's view, it's that a person who's engaged as a sex worker is essentially always operating from a position of inequality. And I understand the argument, but I'm not sure that that's a presumption that we can safely rely on in every circumstance when we're dealing with adult females. Of course, when you take the corruption of children in terms of sexual acts and sexual prostitution, that's not going to be something that any person, any Canadian in a free and democratic society and upholding the values that we do is going to endorse. But the issue is really when we're trying to deal with inequality in relation to children, or we're trying to remedy some of the social ills that we're dealing with here, is the criminal law the best and most effective and precise tool that we can use? And my submission would be it is a very rough tool to either remedy inequality or to deal with the issue of child prostitution.
You mentioned choice, so I'd like to ask some of our panelists about choice. Ms. Nagy, is it your view that the majority of women in this industry voluntarily choose to be in this industry?
The correct way for me to answer that is the majority of the women that we've seen, which is about 300 by now in the last 4 years, were forced into prostitution. We do not deny the fact that there are women in this industry that entered into this industry on their own will, just like I did when I needed money for food and when I almost became homeless.
Can I just ask a question about that?
Sure.
If you need money for food, if you need a place, you need money because you need a place to live, is that a free, voluntary choice?
Absolutely not.
Ms. Sayers, you mentioned a lot of Indigenous women rely on the sex industry to get the money they need to survive. Is that a free choice? Do they freely choose to do this, or if they had a free choice to do something else, would they do something else?
Would you do your work without being paid?
No, of course not. But you
have your answer.
But I have chosen from a number of things available in a way to earn a living. What I'm asking you is, is this the only way? If this is the only way for them to survive, is it really a free choice? That's my question.
Choice and free are such value-laden terms.
Okay.
To say that somebody has a choice to choose something is speaking from a privileged position.
Okay.
We don't question other workers whether they freely choose their job, and we shouldn't be questioning sex workers whether they freely choose their job.
Next question from the Liberal Party is Mr. Casey.
Mr. Chair, Professor Lohman, first of all, thank you for your spirited defense of evidence-based decision-making and your critique of the Farley research. I was interested in your comment with respect to the legal challenge from Pivot on the basis of Section 15 of the Charter. And I am aware that that challenge is effectively stalled or parked. And I would think that there's a real question as to whether it's going to go forward given these most recent developments. Can you explain for the benefit of the committee that challenge and your view of a future challenge on the basis of Section 15?
Two different points.
Yeah.
The Pivot challenge, when it came to Section 15, was talking about the way the protective service potential of the police is not extended to women in sex work, so they do not get equal treatment under the Charter. I think a different kind of Section 15 argument is likely to arise in the proposed legislation, because you have a situation where you're basically saying one party in a transaction, which in a legal sense is a consenting transaction, has no responsibility for it, and the other party is given full responsibility for it. So, as far as I can see, given that many women involved in prostitution do not agree with the prohibitionist analysis of choice. Yes, choice is constrained, but that's true for most manual and service workers, agricultural workers, seasonal workers, on and on and on. But that what you're going to see is the argument that if the police set up bogus escort services in order to get buyers to contact them and make an offer to purchase a service, remembering that the advertising of that service, if it's a person doing it for themselves, will be exempt from the law prohibiting advertising, you essentially have a form of entrapment, because you've potentially got a person who's never bought sexual services before. As I say, supply and demand interact. When we studied clients and asked them reasons about purchasing sex, 41% talked about the visibility and availability. Well, if you have an institutionalized system that does nothing about availability, it seems to me that you have institutionalized entrapment.
Professor Benedette, we heard Professor Lohman talk about the advisability of a reference to the Supreme Court of Canada. with respect to the constitutionality of this legislation. We heard from the minister in very clear terms this morning that that is not going to happen. I don't know if you were here for his testimony. Do you have a view on that?
Well, I think it depends on how you understand the evidentiary record for such a case. I mean, people say, well, let's just refer this to the Supreme Court of Canada and they can tell us whether it's constitutional or not. The evidentiary record that was amassed for the prior challenge had a lot to do with patterns of enforcement and implementation over a very long period of time. And I think the idea that we can simply just take all that evidence and reuse it under a new bill seems odd to me in a challenge that seems to be so deeply rooted in the way that the legislation is enforced and what its effects are. I would have assumed that there would need to be a fairly significant period of time in order for that evidence to be amassed and not simply be relying on the police saying, well, we're doing that anyway, and so here are the effects of that or not. So I can see the argument that, you know, we've just had a constitutional, in a sense, ruling on this legislation. Here's the new bill. Why don't we, you know, skip the stage of going through all the levels of court and refer it right to the Supreme Court of Canada? But I do question then what the evidentiary record is going to be that's based on the actual enforcement and implementation of this bill. I don't know if it's all right for me just to say a word about this argument about entrapment, because I've read the case law on entrapment. I teach criminal law, and I can tell you that the rules about entrapment are nowhere near as broad as Professor Lohman seems to be suggesting that they are. I mean, the police can't just go out and set up sting operations, whether it's for drugs, whether it's for prostitution. Right now, they're doing exactly the kind of thing we're describing for underage prostitution, and there are clear rules about when the police can set up a kind of bogus sting operation and when that crosses the line into entrapment. So it's not like this is a new concept or there isn't already an established body of jurisprudence. Same thing is true for sexual services. It's there in the legislation dealing with underage prostitution. There's a body of jurisprudence that, you know, has interpreted that term where there is some kind of doubt. I find it very odd to say that because most of the buyers, or really all of the buyers, are men and most of those in prostitution are women, that it is sex discrimination to prosecute the buyers. We don't do that for sexual assault, where over 90% of those charged are male. The gendered nature of the industry is what makes it so discriminatory against women. And I find it very strange and not consistent with substantive equality principles at all to turn that on its head and to say that by targeting men for their acts of sex discrimination, we're discriminating against them in some form of reverse discrimination. That's not a version of Section 15 of the Charter that I recognize as it's been applied to sexual harassment in the workplace, sexual assault, and a whole other number of gendered acts of sex discrimination.
Thank you. Mr. Russomanno, just a practical question. If a reference to the Supreme Court, as suggested by Professor Lohman, isn't on, and it's pretty clear from the minister that it's not on, we hear from Professor Benedict that there may well be other good reasons that it's not on, what can we expect in the medium term? So I'm going to ask you to assume a couple of things. I'm going to ask you to assume that when the minister says he's open to amendments, he isn't, and that this bill is going to pass as it presently is. I expect the next stage there will be a challenge. Take us through what happens from there. I know the Bedford litigation started in 2007 and was finally struck down in 2014. So what are we looking at in Canada in terms of legal challenges and the likely timeline given those premises?
Well, in Bedford, as we know, there was just a massive evidentiary record that was amassed by Professor Alan Young and others. Presumably, this would be challenged very soon after the legislation would come into force. One of the first charges laid, I'm assuming, would lead to that challenge. And it's on that evidentiary record that the challenge would proceed. I know from Bedford that based on just the sheer size or the evidentiary record itself, that I don't think that we could approximate the same sample size, if I could put it that way, of evidence as we did in that case. And that undoubtedly there would have to be reference to other jurisdictions which employ models which are similar to the one that's being proposed here. I don't think there's anything that's exactly the same. I suppose you can call this uniquely Canadian. But the asymmetric criminal model, as we know, has been employed in Sweden and other jurisdictions, and that presumably there would be evidence coming out of those jurisdictions as well, and an argument as to how you could transfer the interpretations of the evidence in those jurisdictions to our uniquely Canadian approach.
Okay, thank you. Thank you, Mr. Casey. Thank you for those questions, and thank you, panelists, for those answers. Our next questioner is from the Conservative Party, Ms. Smith.
Thank you, Mr. Chair. And I'd like to ask two questions, one to Professor Benet and one to Tamia Nagy. First of all, Professor Benet, can you make further comment about the constitutionality of the asymmetrical offense in Bill C-36, you know, the purchase of sex as opposed to the decriminalizing of the victim for the most part, about the constitutionality of that and compare it to some of these others that are in the criminal code right now?
If I understand the question correctly, I mean, you have to recall that the provisions that were challenged in Bedford, most of them, leaving the pimping provision aside, which I think actually has a slightly different analysis to it, but applied to both buyers and to sellers, if I can put it that way. And one of the arguments that I made to the court was that, well, we ought to look at those actors separately in looking at the effects of this provision. The court chose not to do that, and of course the challenge was brought by 3 women who either were in prostitution or were formerly in prostitution and now wanted to operate prostitution businesses and to profit from the prostitution of others. And so the focus was very much on liberty and security of the person with respect to those women. If we change the analysis and we say we now have a distinct offense here that criminalizes the purchaser, someone is charged under that offense, it's going to be that buyer, right, whose constitutional rights are at issue. We may have a situation in which women come forward and say, well, we want to bring some kind of a challenge saying that the criminalization of him violates our rights. But it's certainly a step removed from the way that the challenge was constructed in Bedford. There's no security of the person interest for the buyer. His security is not at issue. His liberty is at issue in the sense that he's being criminalized. That's true of all criminal legislation. But that's a far weaker interest than a security of the person interest. Now you're balancing that against much clearer and better objectives. And one of the things that the Supreme Court rejected was an argument by the Crown, particularly the Ontario Crown, that we ought to kind of infuse concerns of dignity and equality into the objectives of the old laws. The court said, no, that's shifting the purpose. We're not going to do that. And, you know, if those objectives had been there, well, that's a different kind of analysis. That was certainly quite influential and I think very present in the Ontario Court of Appeals decision as well. So those are the kinds of factors that I think really do change the analysis. My concern is that if we retain the provision that criminalizes women on the street when they're in places where young people are likely to be present, it undermines the argument that you're going to make about the buyers, that we consider this to be exploitation, we consider it to be discrimination, and we're focusing on the actor who's responsible for that discrimination and exploitation. And I don't think that that requires proving that 100% of women in prostitution are beset with every possible inequality we can imagine and started as young people. That's really, it's an impossible task. It's ultimately fruitless. The question is, what is the legislation doing for those who make up that supply, and why is that supply drawn from racialized women, Aboriginal women, women with histories of state care and sexual abuse so disproportionately? It doesn't have to be exclusively in order for that argument to be an important one in the constitutional analysis.
And for Ms. Nagy, you know, we've talked about, heard a lot about, you know, how everything needs to be decriminalized to make things good for the women so they're more safe. I'd like you to comment on that, and also what happened in New Zealand when it was legalized, because we have a pattern there, don't we? So can you make comment on that?
Right. So I just want to start by saying that as I'm sitting here listening and I zoom out, I'm kind of leaving my body and listening to the argument that we are making. And I believe that this isn't really a debate about our next legislation. This is a debate about where Canada as a society will go next. This is a debate about, if you're a mother, are you okay with your daughter coming to you tomorrow and say, Mommy, I think I would like to be a prostitute when I grow up? This is the debate that we are having. I'm having a really hard time listening to the debate about using the words like sex work. This is not work. When I go to work and I get punched in the face and held down and gun is held against my head to the point that I have to go to the bathroom and lock myself in and hoping that someone will save me, or get beaten, or there are women that jaws are dislocated, I don't like to call that work. What I do today, I call that work. I think what you do, that's work. But when you go to work and every day there is a chance that you're being exploited, beaten, and taken advantage of, I don't think we should call this as work. So maybe for our next debate, maybe we should change our language, because this is actually very offensive. And to go back to your question, Mrs. Smith, decriminalizing, again, I think this is how I would like to answer that question. Overall, I think, because where I'm coming from and because of the frontline work that I work with the police on a daily basis, we see the victims of human trafficking. And yes, of course, we see the women in hotels too that are there on their own will, but they are well over 20, 25. They already accepted that this is the choice that they had made. But those choices led from some very poor circumstances. They have been victimized before. So I think overall we need to make a stand as society on where we're going next and what we would like our next generation to accept, and where would we like our next generation to go, and what they think it would be right for them to do, selling their body or go to university and colleges.
You know, also we've heard, you know, a debate about, you know, as Ms. Sayer says, she's never really met anyone under 18. And yet we find that from the John Howard Society study on prostitution, 14 to 16 is the average age of entry, as you said, Ms. Nagy, about the young people you've worked with, from the childhood victimization journal, the Journal of Interpersonal Violence, 89% before the age of 16 enter into prostitution, 13 to 19 years old. On entry, Lohman Canada, an international handbook on trends, problems, and policies. And I know when Professor Lohman or others have stated, you know, different comments, 52% entered before the age of 16. This is from a study on violence to stop it, Canadian research on violence against women. I mean, the studies go on and on and on and on, validating what you said, is what I'm saying. So having said that, we talk about this turning point, and I think you were very eloquent when you're talking. What,
ask it right now, or your
my
time is up.
My question is to Ms. Benet, do you have any research on this yourself, because you've done a lot of studies on the age of entry into prostitution?
What I can say is that, you know, maybe just to give you an example, there were about 24 women who testified in the Bedford case, called by both sides, called by the government and called by the applicants. And they had the choice of who they could get to testify, who wanted to come forward and be heard. And that was a really interesting cross-section of the women in prostitution. So among that group of 24, there were numerous women who started in prostitution at the age of 18 or younger, including the 3 applicants in the case themselves, who started at 15, 16, and 18. Those were the women who they chose to, you know, to bring forward, to bring this case. There were other women. I think the oldest among that group of 24 was 27, and she had 4 children whom she had lost to Child Protective Services when a boyfriend got her hooked on drugs and then pimped her out. And so it was a range of ages, there's no question, but there were significant numbers of women who had started as teenagers with, with very limited prospects, often fleeing either abusive situations in the home or state care that had itself become abusive. I think it is true, and I think Professor Lohman is correct, that some of the studies that show a very young age of entry are focusing on street prostitutes as a population. And we really have a lot more studies in Canada in particular about street prostitution than we do about off-street prostitution and the demographics there.
Thank you very much. Questions and answers. Our next questioner is Madame Piquet from the...
Merci beaucoup.
Thank you very much, Mr. Chairman, and thank you to all our witnesses for coming today. I think this is an extremely interesting discussion. And I think all the lawyers in the room know that for every lawyer there's a different legal opinion. And so it's important to point out that the purpose here isn't to find out who is right, but which would be the best bill for all Canadian men and women who are affected by this issue. So yes, the Supreme Court ruling is important. The rule of law is important. However, it's important to remember that we should focus on the safety and health of all women and men. So this isn't necessarily a problem that just affects women. I just wanted to start out with that point.
So little time. So my first question would be for Walk With Me Canada, and I just want to say that Mrs. Nagy, I personally was very shocked by your testimony, and thank you very much for coming forward with your personal story. And I think that no woman nor man should be beaten, should be sexually assaulted. I think that everyone agrees here in the room that this is a particularly bad situation for people that you deal with, and it's a crime. And what you described in your testimony is already criminalized by the criminal code, at the Article 227.01, and that it specifies that you cannot consent to being beaten up or being sexually assaulted. So I think that this ought to be clear, that you cannot consent to this, even if at the beginning you might have consented to the act, that you cannot consent to being sexually assaulted. So I think it is included in the criminal code. So I think it's important to be noted. And I just want to say and ask you that all those women or men that you deal with have particularly vulnerable situation, and the government is proposing $20 million for 5 years, and that covers all Canada, so 10 provinces and 3 territories. And we, as you mentioned in your testimony, we know that there's people living in very, very vulnerable situations. So do you think that that's enough? If we're talking about equality here, don't you think that the core problem of this situation is not necessarily the work that they do, but the conditions that they do, and like poverty or history? So do you think that $20 million from the government for 5 years for all Canada is enough?
Thank you so much for your comment previously, and thank you very much for the great question. So I just want to comment quickly on that there is already a criminal code about sexual abuse and assault. Just because it's in a criminal code, it doesn't stop the Johns and pimps to beat up the girls. So that's just my comment to that. And about the $20 million, I don't know if you're aware of that, but in the United States currently, they documented 300,000 young girls between the age of 16 to 21 being trafficked into the sex industry, which is obviously the prostitution. And the American government gave $10 million to fight that. So I think when we look at our Canadian government, and specifically human trafficking, 10 years ago when I was trafficked, there was not even a law about it. Now you guys done such an amazing job to create laws, and many laws to protect, right? And so just a few years later, you actually announcing $20 million, and last year you announced $25 million to fight this. So altogether in the last 2 years, this government already committed more money to Canada and victims of both human trafficking and women of sexual exploitation than America did in the last 2 years.
Well, here now we're talking about trafficking and not prostitution, but it's okay. So my second question will be directed to the Criminal Lawyers Association, and it's important because I haven't had time to ask questions to the aux fonctionnaires publics, and it's important that what is the definition of publicity? Because in the article where there's the immunity, we talk about publicity for your own services. So does it include solicitation? So what is your overview of this article and the immunity? And does it apply to the Article 213, where there's the communication, so solicitation? So what's the difference between both?
I'd like to try to address your question briefly. But before I do that, I was wondering if I could just briefly respond to something that Professor Benedette said. I think it's important when we're looking at the purpose behind this legislation, and there are laudable aspects of it, that just because we are now criminalizing the purchaser does not eliminate the potential for criminalization of the seller. So this Section 7 and the liberty and security of persons argument, you're still going to be getting those arguments. There's still the potential for challenge. They have not been eliminated, even though we are now criminalizing the purchase as opposed to the sale directly. For example, you've got workers who are working together. Both of them may be under 18. That would be an offense. We've talked about the number of young people that are involved in prostitution. We'd be criminalizing both of those young people, saddling them with a criminal record, making it much more difficult for them to ever safely exit once they have that stigma. So I just wanted to say that we're not going to be getting rid of that Section 7 argument. In relation to publication and communication, based on some of the background reading that I've done, and this is admittedly anecdotal, just my own research, there is a concern that some of the advertisers may be targeted by the broadness of this legislation. They may be implicated by providing advertising services. As I read the legislation, I understand it that you can advertise, but it's sort of in a private way. So how much utility it would be to a sex worker to advertise privately, I'm not sure. And it also is going to have an effect on the ability to screen, which I understand is a safety concern for workers.
Those questions and answers. Our next question from the Conservative Party is Monsieur Gauguin.
Chair, thank you to all the witnesses for your testimony today. There's certainly a wide swath. I want to focus on Mrs. Nagy, if I could, please. It's interesting you describe yourself as a survivor at the start of your statement here. There's no question that you are definitely a survivor, and there's an old adage that says if it doesn't kill you, it makes you stronger. And certainly you've made your organization Walk With Me stronger, and you're to be commended for all the work that you've done with them, and to be continued, I'm sure. We'll talk about the $20 million later.
I'll be waiting for your call.
There's been some discussion, of course, of the Charter, as one would be expected. And, of course, one of the things that Bill C-36 focuses on is the protection of those who are subjected to prostitution, violence, and exploitation, such as yourself. And Mr. Romanasano, a while ago, said that in his view that C-36 was in breach of Section 2B, freedom of expression, and, of course, freedom, the life and liberty and security of the person, Section 7. You were describing a scenario where you were being raped, I believe, by 3 Russians. Let's suppose the police authorities would have broken in and rescued you. Would your freedom of expression have been any way breached?
I don't understand.
You couldn't possibly have been doing it.
I don't understand the question.
What I'm
it's just the way you framed it.
Well,
English is my second language
sure.
still.
What I'm
Sorry.
saying is that you weren't freely expressing yourself by being raped by 3 men.
If I would be able to just say I was just raped?
No, if you were rescued, you wouldn't feel that your rights were violated. You don't get it. Okay.
I'm sorry.
He's asking you, if the police arrested them, would you?
My answer is no.
That's kind of what I thought.
Thank
Hungarian
you.
translation.
Very good. Okay, I'll try this one. Now, the Section 7, there's the life, liberty, and security of the person. When you're being coerced to do sexual acts, you're not doing it freely. That definitely goes against your right to life, liberty, and freedom of the person. You're not participating in this freely, right?
Absolutely not.
Now, if the authorities came to you and said, look, Mrs. Nagy, we want to try to help you get out of this sex trade, you're not there voluntarily. Would you disagree with that having happened? Would you be angry at the authorities? Would you say, my right to life, liberty, and security of the person is being violated? I don't want to be rescued.
No, I wouldn't. And as a matter of fact, this is what we do on a daily basis with police officers. That's exactly what we do. We're not targeting, we are not raiding. There's no police raids, just like the opposite party say it in the media. By the way, which the first 3 weeks, that's all you heard in the media. The other side of the story, we were never heard. So that's just my other comment. But there's no police raids. And when we go in the room with the police, we talk to the girls, and you better believe it, in a week, 2 or 3 weeks later, when the person is in the traffic, they will call for help.
Sure.
And they will ask us to take them. And there are times when they beg us to get them out of the room. I was just kidnapped. I've been forced. I can't leave my hotel room. Please take me.
So the great work that your organization does by getting the girls out of this scenario, which they don't want to voluntarily participate in, is actually empowering them, their life, their liberty, their freedom. That's what you do.
That's
so
right.
Greatly, right? There was talk about the $20 million that the federal government is going to fund to organizations. I mean, I don't know exactly which organizations it will be funded to, but I suspect that there will be of the like kind of yours. Can you give us some examples of what type of programs you would put in place if you did have such funding? What would you do? What are the type of examples that would help getting the girls out?
Yes, just 1 second. I don't think it should be just programs like ours. I think there are programs that the opposite side is providing as well. We do believe that there are women there, one way or another, they got into the prostitution. And I do believe that they do get to a place in their life when they decided, I would really like to leave. And it's really hard to leave that industry. So I believe that that money should go and be divided, not just to our side, but to the side where they actually have a full understanding of what it's like to be there for 10 or 20 years, because they can also assist those girls who actually voluntarily would like to leave one day because they decided to, not because the government tells them to, or so on and so forth. But the programs that are already currently available across Canada, there are agencies, not just Walk With Me, and like I said, there are agencies on their side of the fence too, where they offer job counseling, where they offer therapy. There needs to be a lot of therapy once you leave this industry on your own, or once you get rescued. Whichever way you leave, you need therapy. So there would be, and there are emergency safe houses where you stay for up to 3 days, which is one of our services. And then you hopefully go to an assessment center, which has already been done in the United States. In the United States, prostitution is illegal. So when you go before a job, you get arrested, but instead of going to jail, you're asked to go into a treatment center for up to 3 months, which is an assessment center where they actually assess you why you originally entered into this industry and how can we help you out. The same law was just proposed. It's called the diversion program in the Los Angeles district area. After a 3 months assessment period of time where you literally just relax, eat, sleep, and just take a break from life and society, then you are going to a rehabilitation program, which is an up to a year program, which is no different than going to rehab for drugs or alcohol. This is an addictive lifestyle, and you need all the help you can get. And so those are the programs that can help you to heal, go on a real healing journey, and be reintegrated back to a healthy member of society so that you can actually start paying taxes and contribute.
Thank you, sir.
Our next questioner from the New Democratic Party is Mr. Scott.
Thank you, Mr. Chair. I wanted to ask a few questions with Mr. Russomanno, Professor Benedette, and Emilio or Naomi about advertising. It seems fairly clearly established from our both the reading and the earlier testimony that one way or the other, if anybody's going to advertise prostitution services, sex work services, they're going to have to do it somehow on their own. And any third-party involvement risks or will be criminalized. And I find it very hard to figure out exactly what kind of effective advertising that would be. And so one of the concerns I have is that some of the advertising that allows somebody to work out of their home or work out of some kind of a fixed location advertise that fact, screen by way of phone call after a phone call comes in, screen by way of visually once a person arrives, that kind of stuff, is going to be harder because the advertising modalities, the vehicles, the third parties that actually help create effective advertising will be gone, and therefore advertising will maybe push itself back out to the street. I'm not sure exactly. So, Mr. Russomanno, you earlier talked about protective expression, and you were specifically talking about communicating for screening, and how this added provision that Professor Benedette also brought up, where if you're doing it anywhere 18, anybody under 18 can be expected to be, what you're actually getting in the way of is protective expression. Do you see the advertising features of this also in light of this idea of protective expression? That's the question I have. And I wanted to ask Professor Benedette, do you not have any concerns at all about the prohibition on any kind of a third-party involvement in advertising in terms of what it might do by way of risk factors? Because you did isolate the communicating in areas where those under 18 are present or expected to be present, but you didn't focus on that. And I wanted then members of the Sex Work Reform Alliance to comment on the advertising.
I'm going to let Ms. London Weinstein deal with that question.
Well, I think one of the concerns is what is the definition of a public place, whether the Internet would be encompassed as a public place where youth are likely to be. It's a public domain. It's online communication. It's a wild, vast universe out there. Arguably, it could be interpreted as being a place where young people are anticipated to be and therefore would be barred as a method of advertisement. From the reading that I've done, I understand that there are real limitations on advertising, and the advertising actually is under this legislation is going to be of somewhat limited utility because there are real restrictions on where the advertising can take place. And I think in terms of screening, and I'll let the other panelists address the issue of safety, but one of the concerns that arises out of the inability to advertise is the inability to screen, which is directly related to Section 7 concerns in relation to security of the person.
I think maybe I'm a little bit at a loss here to understand how advertising is really protective expression, in particular how profiting from running ads is protective expression. When I look at the kind of ads that run in the Georgia Straight, our local free paper in Vancouver, and the best estimate I have, it's from a few years ago, but someone tried to calculate how much they made, and it was at least $50,000 a week from that advertising. What I see is advertising that is blatantly racist, that divides women up by their ethnic categories and ascribes various kinds of servile categories to them based on race. I see advertising that reduces women to body parts so that they don't actually look like full human beings. I see a culture of advertising that frankly is harassing and demeaning to all Canadian women that is enormously profitable to the organizations that carry it. So I have to say I didn't actually expect to see this advertising provision in this bill, but I would say it's actually a really important step to say that that kind of profiteering needs to stop. And even in jurisdictions that have decriminalized prostitution, it varies, but there are often significant restrictions on advertising. So we're talking about New Zealand. New Zealand doesn't permit the advertising of prostitution on television, on radio. I don't think on billboards as well. It does permit it in print, and the advertising is done by the brothels, who are now actually offering coupons that you can clip out for a discount that you can bring with you to the brothel. I don't see anything protective about that kind of expression, and I don't see what you can do through advertising that once that guy is with you alone in your apartment really makes any difference, whatever it is you've bargained for in advance. So I strongly support this provision, and I think what's being done here is it's a prohibition on advertising and on the advertisers who are profiting, with a clear exception that we're not going to criminalize prostituted women through the back door through an advertising provision. So they are exempted. So I quite like the structure of this, and I think it's quite different than that communicating provision, which effectively criminalizes all street prostitution taking place in residential areas and criminalizes the women for that, which I think is really a backwards move.
The Canadian Alliance.
I'll comment first, or rather my colleague will comment first.
In reference to third parties in relation to advertising, how sometimes sex workers advertise through online sites, and this section makes reference to specific online sites. Sometimes moderators and owners of these sites provide sex work only access to valuable bad date list information. Criminalizing their actions would eliminate that access area and potential safety and extremely valuable safety mechanisms.
Now, I'm not just reduced to an object or a body part in my advertising. I explain a little bit about my personality and the kinds of services I'll offer and the prices that are attached to those services, as well as the services that I do not offer. And so when you're allowed to advertise, you have an opportunity to negotiate, to let people know what it is you do. And now if I can network as well with my colleagues who also advertise, then I can check references. If I can't do that, I can't check references. I have to go out into the street to find my clients and seek them out elsewhere.
Finally, I think we have Mr. Decker from the Conservative Party.
Thank you, Mr. Chair. I believe, Ms. La Liberté, what you were just describing, what you do, is exactly what C-36 would allow. That's certainly my understanding.
Actually not. Because C-36 would shut down all the website that I can advertise.
No, not if you pay for it on commercial terms.
Excuse me?
Not if you pay for it on a reasonable commercial terms. In other words, if they're not exploiting you, you can do that. You can set up your own website, but we'll...
Yeah.
Right, but we...
question and answer.
You consider me as an exploited person anyway.
I'm saying if you do it yourself, if you pay someone to set up your own website, describe the services that you're describing, my understanding is that you will not be criminalized. That advertising will be allowed.
We'll see that in action.
But we will. Let me focus on something else. A number of our witnesses have mentioned New Zealand, Mr. Chairman, and some have said they think perhaps the ideal model. I think the Criminal Lawyers Association said that. I believe Professor Lohman said that. The Alliance may have said something similar about it. Ms. Benedet, you've mentioned New Zealand. I want you to tell us what the situation was before they passed their new laws, and compare it to the situation now with respect to street prostitution and with respect to Indigenous women. Can you tell us what you understand the experience is there?
Well, I guess the first thing I would say about comparisons to New Zealand is it is important to understand. I think it's useful to look at other jurisdictions, and I'm certainly someone who's asked Canada to look at the experience of Sweden. But New Zealand is a very small, geographically isolated country. Its nearest neighbor, Australia, has mostly legalized prostitution. The Canadian experience with the United States right next to us is different, and so whatever has happened, for good or for ill, you have to be a little bit careful about those kinds of analogies. I can say that even looking at research coming out of the New Zealand government and coming out of the New Zealand Prostitutes Collective, which is sort of the most, the most established group supporting the New Zealand model, that the general trend is that reported incidents of violence have remained the same. So they are lower indoors than on the street, but they have remained the same, both prior to the legislation and after. That has not changed. The number of women on the street in street prostitution in cities like Christchurch has not changed since the legislation was passed, and it's the women on the street who are disproportionately the Aboriginal women, the Indigenous women. What has changed, and again, this is, the group supporting the legislation verify this as well, is quite a significant increase in the number of foreign women, now Chinese women, in prostitution in New Zealand. And that's estimated to make up about a third of the industry, as I understand it. And those women are not legally permitted to engage in prostitution because they are not citizens. So the law there requires that you be a citizen in order to engage in prostitution.
So in the Bedford decision, the Supreme Court told us that street prostitution is the most dangerous form of prostitution. Would you agree with that?
Well, I think we have to be a little bit careful about that because, we've had, in fact, in the last few years in Vancouver, several murders of women who have been prostituting either out of their homes or in sort of trick pads that are used for
it's
that
dangerous in many
purpose.
locations, but...
So in terms of degrees of danger, the reality is that taking the very same women who are on the street and moving them indoors, it's not the location that is dangerous. It's the men who seek out those women. And so ultimately, it's the women who are at the bottom of the social hierarchy in whatever country you're in that have to endure the most brutal and degrading forms of prostitution, whether indoors or outdoors.
Can you comment on the ethnicity of the people who comprise most of the street prostitution in New Zealand? Do you have any information on that?
Well, yes, and I think, all of the reports going back to many of the reports that have been done have shown that in many Canadian cities, the concentration of Aboriginal women in street prostitution vastly outnumbers their representation in the population. And certainly we see that in Vancouver. We see that in Winnipeg, and I know that Andrew Swan, the Attorney General of Manitoba, has really made a point of highlighting that as well. So I think there's no question that there's disproportionate representation of Aboriginal women on the street.
And is that true in New Zealand as well?
Yes, and that's true in New Zealand
I'd like to
get
Ms. Sayers' perspective on this. You work, Ms. Sayers, with Indigenous women, you said, here in Canada. What is your understanding of the situation in New Zealand? Who are the women who are largely on the street there? Are they Indigenous, and has there been any reduction when they've moved to this new model?
So in 2007, there was a survey done on over 700 Maori sex workers. That's the reference to their specific nation. They did say that they were no longer under the threat of violence, but they also reported that they felt more safer in reporting violence, not just from clients, but also from violence from the public. We have to remember that violence comes in many forms and not just from clients. As I stated in my presentation, it includes institutional and systemic violence.
Okay, so would you say that there are the same number of Indigenous women on the streets in New Zealand today as there were before they changed their laws?
There is no change.
There's no change.
There's no change, but that's not.
I heard the rest of it. I just wanted to clarify that point.
Yep, but they feel more safer in reporting incidents of violence, which is the key.
Last question.
Okay, so I'd like to hear from Professor Lohman on this point. He mentioned that total decriminalization is the way that he thinks Canada ought to go. He also mentioned zoning bylaw restrictions, and where the city decides that it's going to be in a particular place, that isn't necessarily a way of making it safer. So I'd like to hear from him on where he thinks street prostitution would be safer. What kind of bylaws would he be in favor of supporting, or that he thinks would be useful in making street prostitution safer for prostitutes, and can he give us any insight into the New Zealand experience in that regard?
I mean, my first instinct is to say that we all seem to be expecting a silver bullet, a panacea, and there isn't one out there. This is a very, very complicated situation. I would like to see prostitution taken off the street, but I realize when I'm talking about women in the downtown east side, we talk about them going indoors. There's no indoors for them to go to. They're homeless. Prostitution is a reflection of many other problems, their involvement in it. what we've noticed over the years in Vancouver is that whenever police have simply had an initiative against prostitution in certain residential areas, it automatically gets displaced. But the displacement is often unintentional. When you have a situation where the police say, okay, don't work in this area, work in this area, the women move. The reason I mentioned bylaws is that you could presumably set up some kind of zone whereby some kind of business activities generically regulated, and this could apply to other kinds of prostitution locations, where they would be located. The most important part of whatever kind of regulation that would be introduced in that vision, the most important thing is to involve the people who are going to be regulated, i.e. the sex workers, the people who we never ask about what kind of regulations would make sense for them. So if we, and that's why I don't just come out with a particular plan of action. One needs to sit down with the people who these laws would apply to find out what would make sense for them, because if it doesn't make sense for them, it isn't going to work.
Okay, that's your. Can you briefly comment on New Zealand, and then we have to wrap up, Professor? Professor, can you hear me?
Sorry,
What is your view of the
Sorry, I didn't hear the question.
So what is the experience in New Zealand with respect to the regulation of where street prostitution is allowed to be carried on?
I'm not fully conversant with exactly how the legislation of street prostitution works. We know that street prostitution still exists. There has not been a silver bullet, but I think if you go through the research, there's a lot more to discuss about the New Zealand experience than we heard today.
Okay, thank you very much. Thank you for all of our witnesses for coming. We will be having committee meetings. Well, we have another one after this. We have one all till Thursday at 5:30, and then the committee will decide what they'll do next after that. So, and they're all televised, so you can watch or come live if you want. Thank you very much for your testimony. With that, we will adjourn till 3:30.